Hello everyone, my name is Graham Raper. I'm the General Manager for R&G Health and Safety Coaching. Welcome to this webinar in which we're going to take you through the Health and Safety at Work Act and how it relates to you as a landlord or a property owner who rents out their property. So a wee bit of background on R&G Health and Safety Coaching. We're involved with health and safety related programs since about 2003, but more importantly, since the introduction of the new Health and Safety Work Act, we've focused on how that interacts with people and businesses to ensure that it meets the intent of the Act, which is quite different to the old Act. As a result of that, we're pretty pleased that our clients have recorded over 1 million hours of lost time injury accidents. So in other words, they haven't had any injuries that have required a staff member to be off work, which is obviously what everybody's hoping for. This isn't, of course, minor scrapes and cuts that may occur, but don't require time off work. And amongst the team that we have here, we've got over 40 years experience. But over the last year or so in particular, just through no particular reason, we have been concentrating on rental property management owners and rental property management companies and the relationship between the Health and Safety at Work Act and the requirements of those for landlords. What do you need to know just before we can hang on, if you have a question throughout this webinar, there's a little chat box that you can put the question in. And following the webinar, the team here will collate the questions and we'll write up some answers for you and we'll send them out to you so everyone can see what's been asked and any questions that relate to that you'll probably find quite useful. So the first thing on there is what we're going to discuss is what is a PCBU, the legislation and the requirements by law, what's in common. And what's in common, we're related to the acts that directly apply to landlords. The risks of an unlawful premise, the unlawful premise being the terminology related to rental properties, and some examples. So what is a PCBU? It comes from it's an Australian term after the Pike River tragedy and the adoption of the new Health and Safety at Work Act. Most of the information and the model has come from Victoria, Australia, which is now used in most parts in Australia. So out of that comes this terminology, PCBU, person conducting a business or an undertaking. As a landlord, are you a PCBU? Emphatically, the answer is yes. And certainly don't take my word for it. Just Google it and you'll find that there are many, many, many reports from major legal firms in New Zealand that explain that a landlord is a PCBU. And a PCBU is defined, are services requested or offered? If the answer is yes to that, then you are a PCBU, and therefore all health and safety processes and law need to be applied. So in simple terms, people are paying you money to rent your property, and so therein lies the fact that you are a business and a PCBU. Just to help with how that fits within the rental property management process, as the owner of the property, therefore the landlord, you are the officer. You're the person who sets the standards and sets the expectations of how work or any work is carried out on your premise. So that includes any contractors that go on, or as a PCBU, if you go onto that property, that is your workplace now. If you employ contractors, and just for A useful bit of information: a rental property management company is a contractor, in the same way as if you used a painting contractor or anybody else. Those contractors may in turn subcontract out some work. Everybody has a role to play. Everybody must be compliant with the Health and Safety at Work Act. But more recently, it has been around for a while, but it's certainly come to the fore more recently, are the three acts and how they interact. With the Health and Safety at Work Act 2015, the Residential Tenancies 2016 Amendment Act. And what we're talking about in there was included in the Residential Tenancy Act of 1986 regarding health and safety and so on. But obviously with the new Health and Safety at Work Act, it's become more evident that there needs to be compliance. And then in 2017, the Healthy Homes Guarantee Act. Now these are the current parts of that act that are enforced now. Obviously, things like insulation come in July. What we're talking about today are currently in law. So what's in common? Well, the Health and Safety at Work Act is an enactment of law. Now, it's important to understand that it is an enactment because throughout the other documents and acts, they talk about enactments. So the Health and Safety at Work is an enactment. The Residential Tenancy Amendment Act of 2016 and the Healthy Homes Guarantee Act of 2017 require all landlords to meet enactments of law. That's all enactments of law. In fact, you'll find in one of the sections here, there's just a wee quote there, a failure to comply with any other requirement relating to health and safety under any enactment. Under the 2016 amendment, I think it's section 72. And this is how it comes together. So we compliance circle. So we have the Health and Safety at Work Act. Now section 35 is interesting in that it requires a person, or a court can deem a person, needs to ensure that they are operating within the law or within other enactments, which we've mentioned before. And it's interesting enough whether or not it's related to health and safety. So as a business, as a PCBU, you have the responsibility to ensure that anything else that you do is lawful. Then we look at the Healthy Homes Guarantee Act. There in, you'll see there, Schedule 7. It talks about landlords' failure to meet obligations in respect to, in particular, the health and safety requirements. Now, the $4,000 there is the fine for failing to meet any enactment. It simply means that if the residential tenancy investigation team were to ask you for evidence of your health and safety program and you couldn't provide it, it's a $4,000 fine. Then we have the Residential Tenancies Amendment Act, which clearly defines, it's actually 78, I think I said 72, clearly defines what it is regarding enactments and health and safety. Now, any one of those failures and any one of those can lead to prosecution in their own right, or as you can see, when they're all linked together, either one way or the other, it provides a complete circle of compliance. So what are the risks of an unlawful property? I mentioned it briefly before. The Healthy Homes Guarantee Act 2017, is scheduled there. A failure to meet an obligation, respect, and in this case health and safety, can lead to fines up to $4,000. Also, and this is subject to investigation currently, which is why it's very important, tenants can also apply for partial or full reparation of the rent they've paid while the property or the premise has been unlawful. The maximum amount, according to the Act, is $50,000. I'll relate that to in another slide, but be aware it's not just a $4,000 fine. If the tenant goes to the tenancy tribunal and says to them, the property was unlawful because the landlord didn't have health and safety, for example, then it's an unlawful property. There's just been some recent cases. One case was with no smoke alarms. It was $17,000. Now that related to the fine and also for the compensation to the tenants for living in a place that was unlawful. MBIE have put out a very good document that talks about what is or isn't an unlawful premise. So it's in two parts, the landlord's obligations and, of course, the building itself. So no smoke alarms breached that section of the Act, which we just talked about, and the fines were obviously substantial. The Dunedin students successful in getting their compensation was again related to unlawful property. Now, the amount of money they received has been suppressed. However, we do know that they claimed $100,000 in compensation. The maximum they could have got, obviously, was $50,000, but the amount has been suppressed. But nonetheless, they did receive compensation. So, what's in it for you in engaging and ensuring that you have appropriate processes and systems? Well, we provide the nationwide recognised implementation program, which is consistent throughout New Zealand. Now, consistency is the key, obviously, to ensure compliance. All the documentation and guidance on implementation and what to do are provided within the service that we provide. The documents are contained on an electronic portal, which you have your own personal login for. You're also able to upload any documents that you related to health and safety you may wish to hold on there, thereby providing you with a complete health and safety file. Now, that is written evidence, and that is only part of what you're required to do. Having documents on shelves gathering dust are a very good vacuum cleaner. That's about all. They do not protect you from should something go wrong, unless you can demonstrate that you've put those policies and processes into practice and evidencing that practice. Real-time legislation updates. The most recent one is we've provided all our clients at no cost with a solution for how to manage the asbestos issue and ensure that it sits within the right category. That's just part of what we do. It's just part of the service we provide. We also have one related to methamphetamine and so on. But all of this helps you to become compliant. It does not make you compliant under the Health and Safety Act. What is really important is that some form of audit process of contractors who are the risk, who create the major risk, is undertaken. This is evidence of you being able to demonstrate that not only did you seek a written confirmation from your contractor, but you've gone to see that the contractor is doing what they say they're going to do. Now, within the system, we provide a very simple audit tool for that, and that is within, so you're able to go and do your own audits. Just be aware that failing to do that kind of process, checking up on what they're doing, will basically lead to documentation of no value in any defence should it go wrong. So you can conduct your own on-site audits, or for additional fees, which we're happy to discuss with you, we can conduct them for you. This is anywhere in the country. We have a team of assessors that can do that for you. So the next steps, following the presentation, you'll receive an email from the team with a recording and a direct link to the website, where you can purchase the program and we get you started. The cost involved for the landlord is $399 plus GST. Just again, the little note there is be aware that we are providing you for that fee the information and documentation and guidance on how to do it. There still needs to be the physical management of contractors to ensure they are doing what they say they're going to do, and that's done proportional to your risk, but it must be done. So we can talk about that if you wish us to undertake those. But a member of our team will be in touch with you over the next few days and follow up with any questions you have. Anybody that through this process has used their chat box and asked questions, we will answer those questions and circulate it widely so everybody can get an understanding of people's questions and the answers that relate to that. So once again, thank you for taking the time to listen to this webinar. We hope you found it useful. Just be aware though that while it might sound daunting and all a bit too much, it's actually relatively simple and relatively inexpensive. To ensure that is related to the various acts we've talked about, you can deem yourself to be a lawful landlord in conjunction with the other requirements. So feel free to make contact and we look forward to talking to you shortly.